Chapter 2, what are the penalties for driving while under suspension in Ontario? The penalties for driving under suspension in Ontario, they're severe. The penalties can be found in Section 53(1) of the Ontario Highway Traffic Act, and I'm going to take you through a summary of what those penalties are. The first and probably the most impactful for people is a mandatory 6-month driving suspension. What that means is when you're convicted, there is this 6-month driving suspension in Ontario. That's mandatory. And it does not matter that you have to drive for your work. It doesn't matter if you have to drive for your family or you have to drive for health reasons. This is a 6-month driving license suspension. It's written in the law and there are no exceptions. The second part of the penalties are fines. There are possible fines that range from a minimum of $1,000 and they go all the way up to $5,000. And there's an additional 25% what they call victim surcharge. The third aspect of the penalties is possible probation, and there could be a probation order of up to 2 years. As well, there could be jail time. That jail time could be anywhere up to 6 months. Now, the prosecutor will typically seek jail time in circumstances when you have multiple prior convictions of driving while under suspension. Now, if you've never been to jail before for this charge, a prosecutor will typically ask a few days to a few weeks. Now, with each future conviction, the prosecutor will seek additional jail time all the way up to 6 months for each conviction. That's the first big bucket of penalties. There are other negative things that can happen, namely your insurance rates will dramatically increase. So when you're convicted of driving while under suspension, your insurance company will place you in a high risk category. And the impact of being high risk will be a dramatic increase in your insurance. And it's even possible that your insurance company will cancel or may cancel your insurance coverage as a result of this conviction. Which leads to the next question, which is about jail. I mean, can you go to jail for driving while under suspension? Well, as I just mentioned, you can. You can go to jail for driving under suspension, and that jail time could be potentially 6 months for each conviction. Okay, so if you got 2 convictions, possible jail times up to a year, again, if you have multiple prior convictions. That leads to a question of why are these penalties so incredibly harsh? And the reason why is that driving while under suspension in Ontario is considered what's called a public safety offense. Now, here's what that means. Think about it this way. A typical vehicle, let's say a car, weighs about 4,000 pounds, about 1,800 kilograms. That is a lot of weight to be moving on a set of wheels. Now, in this context, don't think of a car. Think about your vehicle as a weapon. A 4,000-pound weapon that can kill someone, that can cause a lot of property damage, that could put a person in a wheelchair. That's what it is. It's a 4,000-pound weapon. And in the context of a 4,000-pound weapon, the lawmakers made a public policy decision. They simply just don't want people driving a vehicle with a suspended license, and doing so can pose a real danger to society. Remember, 4,000-pound weapon. Now, because driving while under suspension is considered a danger to the public, the lawmakers really treat this charge differently and more harshly than a standard traffic ticket. This charge is actually classified on a whole different part of the Ontario Highway Traffic Act. It's called a Part 3 public safety offense. And severe penalties are given because the lawmakers only want people to drive that are allowed to drive and that follow the rules. So that means you need to be properly licensed. And if you're suspended, you can't drive. Okay? And if you do drive, the province is going to punish you very harshly. Now, yes, the province will take your license away for 6 months. Yes, the lawmakers know this is harsh. Yes, the lawmakers know that you may lose your job. And if you lose your job, then you lose your ability to feed yourself and your family. Yes, the lawmakers know all that. But guess what? That is a price you're going to pay when you pose a public safety risk. And guess what? If you keep driving, they're just going to keep making the penalties harsher and they'll put you in jail. Harsh? Yes. But again, you're driving a 4,000-pound weapon, and if the fines and suspensions aren't going to stop you from driving after you've been convicted, then jail time may teach you the lesson that you need to keep off the road if you're not licensed. So, why are the penalties listed as a range and not fixed? So for example, the fines are anywhere from $5,000 up to $5,000, or probation, or up to jail time or probation. So it's a range, it's not fixed. And the reason why is that the lawmakers did this on purpose. They gave the prosecutor a range of penalties because the penalties are not fixed. It's a range. It's like a prosecutor having a toolbox of penalties. And this is why, and very different than penalties for simple traffic tickets. So if you speed, okay, it's very simple. In the law, it says the fine is X dollars and these many points. There's no discretion as to what your penalty is going to be. But if you're charged and convicted of driving under suspension, the penalties that you're subject to have a range, okay? And they're not fixed because the severity of driving under suspension is such that the more severe your case is, the more severe the lawmakers want your penalty to be. That's why it's like a toolbox of penalties. Now, who decides on what the penalty is going to be? Because it's a range of penalties. Ultimately, it's someone called the Justice of the Peace. They're going to be the final decision maker on what your penalty is going to be. However, the prosecutor, and that's the person who works for the Ontario government that's in charge of prosecuting the case against you, does have a say in what the penalty is going to be. But ultimately, it is the Justice of the Peace who's going to decide. Brings up another question, which is what factors go into the decision as what the penalty is going to be? Because again, they have this toolbox. How are they going to apply the tools in the toolbox to your penalties? There are a lot of factors that go into the decision-making process about what your penalty would be. Now, some of these factors include the following. First, critically, have you been convicted before driving under suspension? So prior convictions, that is a critical factor in determining the penalty. Generally, they also look at your driving record. What does that look like? Is it clean, or is it just a lot of prior convictions, either on that charge or other charges? If there was an accident, and if there was an accident when this event happened, was anyone hurt, or please, hopefully not, was anyone killed? And how your interactions were with the police officer when the police officer gave you the summons, that will all impact on your penalty. Now, leads to another question. Can you get convicted while driving under suspension but not be subject to the 6-month driving suspension? Bottom line, no. Absolutely not. The 6-month driving suspension is mandatory, and there are no exceptions to this rule because the 6-month driving suspension penalty is actually written into the law. And there is no person that has the legal power to remove that 6-month driving suspension part of the penalty.